1 p.m. Convened. Roll call.
Commissioner Gravel,
Here.
Commissioner Slipper,
Here.
Commissioner Spencer,
Here.
Secretary Examiner Siebert, and here.
Thank you. A motion to add the following before agenda item A is requested by the chair to select and appoint a commission pro tem to preside this meeting. We have a motion.
Motion. I'll second.
We have a motion and a second to select and appoint a commissioner pro tem to preside this meeting. We'll now have discussion and questions. The commissioners need to decide which in the motion, who you want to name as the to preside if the motion carries.
I'll make a motion that Mr. Slipper be pro tem.
I'll restate the motion here. Are you going to second that?
I'll second that.
Okay, we're a little out of order. So I'll restate both commissioners agree to cancel their current motions. I'm going to restate it with the name.
Okay, I'll agree. Please say that again.
Going to cancel the motion that's on the table. There's two motions. That's not correct. So we're going to cancel both motions, and I'm going to restate the motion with you as the appointee.
Okay.
Okay, the chair is looking for a motion to appoint a commissioner. Should have followed. Should have followed Mr. Siderius. A motion to appoint Commissioner Slipper as Commissioner pro tem to preside this meeting. Looking for a first.
Give it a first.
Okay.
Second.
Okay, we have a motion and a second to appoint Commissioner Slipper as pro tem to preside this meeting. We will now have discussion or questions.
No discussion. No discussion.
The chair recognizes the commission counsel, Mr. Siderius. His recommendation is a good recommendation. From my perspective, I think we need to avoid any possibility of appeal. Any further discussion?
No, I thought that was good guidance.
Yes.
And nothing on a personal nature, just good guidance.
Not at all. Not at all. Okay. Hearing no further discussion, we'll take it to vote. All in favor, raise your hand. Motion carries unanimously. I now turn the meeting over to Commissioner Slipper.
I hadn't been paying attention to the screen. I recognize the lady on the bottom. The gentleman on the top is.
Mr. Siderius, Bob Siderius.
Gotcha. Thank you.
But before I leave the chair, everybody needs to know that this meeting is being recorded via Zoom and there will be no public comment.
Well, then we can proceed, John, with the arguments that will come before us today, and that would be first, Ms. Norton. Are you
yes.
hearing me okay?
Yes, I can hear you. Can you hear me okay?
Well, you could be louder.
I can make it louder. I don't have the remote set up for that yet, so I'll just.
And is Mr. Thinnell here? I don't see him on my Zoom.
See Mr. Fox's
Correct.
turn? What do we
I was
know
going to
about
ask the
that?
same question. I didn't know if he was in the gallery there in person.
believe that he was going to be here in person, was he not, Jody?
He replied back that he would be on the Zoom meeting.
And I see Paige Cruz, Paige Schurz is showing up now, and she is with Mr. Thinnell's office.
Okay.
Oh, and there's Mr. Thinnell.
Yeah, I just didn't want to get started before they were present.
Is this good?
Oh, yes, she's with,
Okay, perfect.
yes, okay.
So the person that just came on the screen with the headphones is,
Dan Tennell.
say again, please?
This is Dan Tennell.
Thank you. So, City Attorney Norton, if you would like to proceed with, as the moving party, make oral argument in support of the recusal of Mr. Gravel.
Thank you, Commissioner Slipper. So our office serves as city attorneys, and before I go too much further, can you hear me okay now?
Yes.
Okay, so our office is representing the city of Soap Lake in this matter, and we've brought this motion to challenge the participation of Commissioner Gravel under Rule 1, Section 10 of the Soap Lake Civil Service Rules. The basis for the challenge is due to violations of the appearance of fairness doctrine, which requires recusal as a remedy. We are not seeking removal, just recusal. This motion is not intended to question the character or integrity of the commissioner. It's also not a proceeding intended to bring any personal liability exposure to the commissioner. It's simply a formality required by the particular hearing process. And I do want to say that we appreciate Commissioner Gravel's passion for service, and we are certain he does an adequate job in other roles. However, he's conflicted from this proceeding for the reasons that we stated in our materials and that I will summarize just briefly in this hearing. And to be clear, we're not alleging that he intended to violate appearance of fairness, although arguably given his history of public service, he probably should have known his conduct could raise concerns on that level. But if he is not recused from this proceeding, the conduct that objectively violates the doctrine, or for his conduct that objectively violates the doctrine, then there's a substantial proceeding risk that the proceeding will be invalidated. And so just a little bit of background as we addressed in our pleadings, as you may know, the appearance of fairness doctrine is a well-established rule of law that requires government decision makers to conduct what we call quasi-judicial or non-court hearings in proceedings in a way that is fair and unbiased, both in appearance and fact. The doctrine requires public hearings that are adjudicatory or quasi-judicial is the term we give them, meet two requirements. The hearing must be procedurally fair, and it must appear to be conducted fair and impartial by a decision maker. It's been confirmed by courts and by RCW 4236010 that it is a requirement embedded in certain civil service proceedings. So even if it's not expressly mentioned in your rules, you do have to follow it. In this particular proceeding, as you're probably aware, the commission is sitting as adjudicators or judges for purposes of Chief Cox's appeal. So like judges, you have to be able to be fair and free from bias or the perception of bias. And it's a little different, as you may know, from your regular monthly meetings where you operate in a legislative capacity. This proceeding is different and requires the formality of a court-like process. So that's where some of these violations come into play that wouldn't normally be violations in your regular hearing processes. So we are seeking the recusal of Commissioner Gravel based on objective conflicts of interest that would violate appearance of fairness if he were to participate in the adjudication of this matter. And so, you know, the test for fairness is, would a fair-minded person in attendance at the hearing say that everyone was heard who should have been heard and that the decision maker was impartial and free from outside influences or biases? Washington State Supreme Court identified 3 major categories of bias, which we've briefed in our materials, and that includes personal interest, prejudgment of issues, and partiality. And in addition, the RCW 4236060 expressly prohibits ex parte contacts with a party outside the hearing. So unfortunately, Commissioner Gravel has engaged in all of these prohibited behaviors, and any one of which would warrant his recusal from the hearing. And we kind of briefed him ad nauseum, and I'm sorry for all the briefing. I will just try to highlight and summarize some of them. First, Commissioner Gravel engaged in improper ex parte contacts outside the hearing, some of which cannot be cured. And just so you're aware, ex parte contacts means one-sided contacts with a party about their side of the case and without the other side being present. Although some of these occurred before the appeal was filed, others did not. The conversations that occurred before the appeal really can't be cured at all to the extent they cause him to be a witness and participant in the disciplinary action. In particular, both he and Chief Cox admit in their materials that he spoke to Chief Cox after being placed on leave. As you may know, the mayor issued a directive that Chief Cox was not to have any communication outside a legal advisor while he was on leave. So because he admits to having this communication, if he's not recused, he may be required to assess whether his own conduct violated the directive and led to the chief's discipline. Part of the reason the chief was disciplined was for engaging in these, was for speaking to others in violation of the mayor's directive. In the Fulweiler case, which is cited in our materials, the Supreme Court expressly held that a commissioner could not be both a witness and a judge in a proceeding. And he would essentially be that if he is not recused in this particular case. He's also had ex parte communications with a then city council member regarding matters learned in executive session. And so as the city council member, that's a one-sided contact with the city in that particular case, potentially learning matters discussed in a confidential executive session. After the appeal was filed, he also sent a few emails to the city attorney's office, which, as you know, I'm representing the city in this matter. Those have a better possibility of being cured. I realize they were potentially unintentional, but they are a true violation of the statute, and that they were ex parte contacts with our office after the appeal was filed and regarding the matters at issue in the appeal. So these ex parte contacts and their impact on the discipline at issue in the appeal really prevent Commissioner Gravel from being able to serve. He's also demonstrated prejudgment or bias. He's spoken publicly about expressing an opinion that the chief was slandered or wrongfully accused of being corrupt, and that the vehicle transaction was permissible. Most recently, in his own reply material, he doubled down and stated that the chief was incorrectly accused of being corrupt. So, in this particular assertion being made after the appeal, he's also stated in his reply that he believes the city prejudged the discipline against Chief Cox. And this was based on the article from the Quad City Herald that the city actually had no participation in providing comment. And other citizens, again, this is appearance of fairness. So it needs to be fair in fact and appearance. Other citizens have noticed that he's made comments that support the chief and has prejudged the issues. Therefore, the appearance of fairness cannot be maintained to the public. He's also independently investigated matters related to the city's action, knowing that this commission could face this appeal. As a reminder, for a court-like proceeding, the commission's review of issues is confined to the record as submitted by the parties before the commission. So you can't decide matters based on facts that are not in the record, that the parties have not themselves submitted. So any separate investigation may result in information or reliance of materials or information from outside the hearing process. In fact, he's kind of demonstrated that through his investigation, he's already prejudged certain issues by saying that Chief Cox committed no acts constituting corruption, Chief Cox has committed no unethical acts, and Chief Cox's purchase and sale of the police vehicle was permissible. So such a public assertion of the facts and statements of his legal conclusion of a matter before the commission based on his own prior investigation is a plain violation of the appearance of fairness. He's also demonstrated personal interest or bias or partiality to one party over the other. Partiality is sort of the antithesis of a fair hearing and deliberation. It is demonstrated by the existence of hostility or favoritism and can turn otherwise carefully conducted hearings into unfair proceedings. And he's demonstrated partiality through his conduct and personal relationships. I know he disputes it, but he has a personal history with Chief Cox. He hired the chief. He's never disciplined the chief previously. He's had private business dealings with the chief. These lead to an appearance that he supports the chief. He's also made comments against the city or expressing distrust in the city. For example, he stated he sees things differently from the mayor, and this was just stated in his most recent reply. He's publicly accused the council members of deleting recordings, and he's also stated that he believes the city is misusing resources and maybe destroying public records. So all of these sort of demonstrate that he is maybe not a supporter of the city and would unfairly criticize or unfairly review the city. And again, under the test of fairness, it's that no reasonable person could conclude that the city would be given a fair trial based on these actions. So these are just a summary. And just to briefly address, I know both Chief Cox and the commissioner mentioned our monitoring of social media as some form of improper procedure. And again, to be clear, our office is representing the city. So we are not subject to the appearance of fairness in the same way the commission is. So we're not required to have an unbiased opinion, and our role is as an advocate for the city to present the city's case. So any reference to our monitoring of social media or newspapers is entirely irrelevant. Ultimately, we are requesting that you recuse Commissioner Gravel for these conducts. Again, I don't think there was any bad faith or intent to violate this rule, but it is what it is. Under RCW 4112-030, 2 members of the commission constitute a quorum and are sufficient for the decision of all matters that you need to decide as a commission. So we are requesting that Commissioners Slipper and Spencer grant the city's motion. And if the hearing proceeds without recusal and a violation is proved, the challenge decision will be invalidated and a new hearing would likely need to be conducted. So a lot of potential wasted time and energy if we don't start this right from the outset. And I know I said a lot. I know we've filed a lot. So if any of you have any questions, please let me know.
We don't have any questions. Thank you. Mr. Thinnell, attorney for Mr. Cox, your argument in opposition to the recusal.
Well, actually, before we get to the argument, I believe that the commission is required to allow me to call witnesses in this proceeding. And so I'd like to call and have sworn in the mayor and have the mayor testify before my argument, since we're entitled to put on evidence and have witnesses called.
I'll refer that to Mr. Sidarius for advice for the commission. We're not hearing you.
Bob, you're muted.
And just for the record, I object to that request since we were not given any prior notice that any testimony would be requested.
Would you hold on, please? Thank you.
So witnesses are allowed to be presented for this type of a hearing. The question of whether notice should have been provided is something that is not before the commission at this point. That there was never any type of a pre-hearing schedule. So while it may have been maybe a professional courtesy for Mr. Thinnell to provide notice to Ms. Norton, I don't know that there was any requirement that he do so. So I think Mr. Thinnell should have the ability to bring a witness, and Ms. Norton should have the ability to cross-examine. And if there are things that come up that require this hearing to be continued so that Ms. Norton might have an opportunity to present contrary testimony, that may be where this goes. But I guess that will depend upon what the witness has to offer.
So you're advising to allow the witness at this?
I am.
And if that witness takes a chair here somewhere, is it under oath? Is it?
He does take a chair, and yes, the presiding commissioner should place the witness under oath.
John? Go ahead.
I agree to it.
Yeah, I don't know what more I have to learn from hearing this. However, yes, please proceed.
Let me offer a suggestion. If you could have the witness raise his right hand and ask him if he does swear or affirm to tell the truth, the whole truth, and nothing but the truth. I think that would be adequate for swearing the witness in.
Okay, and Mr. Spinelli, you're going to ask questions of the witness, is that correct?
After the witness is sworn in and takes an oath to tell the truth, I will.
Okay, and then Ms. Norton has the right to follow up with questions as well?
Yes.
Okay. Well, Mr. Gravel,
Yes.
who was the witness to be? I thought it was Mr. Gravel.
No, it is the mayor.
Oh, excuse me, I've got the wrong person here. Well, it doesn't matter. Everyone's treated equally here. Mr. Mayor, you're going to be a witness here, subject to questions from the attorneys, and will this be, what are the terms, Mr. Sidarius?
It'll be under oath,
Under oath?
and he will be sworn in. Yes.
To be sworn in under oath and that what you state is true. Okay.
So if you could
Proceed.
just have him raise his right hand
So raise your hand.
and ask him if he swears or affirms to tell the truth,
You swear or
Yes, sir.
affirm to tell the truth,
the whole truth, and nothing but the truth.
the whole truth, and nothing but the truth.
Whole truth, nothing but the truth.
And he should say that he does.
I do.
And he does affirm that, yes.
Thank you.
Mr. Sedaris, may I proceed?
Presiding actually should be the one to allow
Yeah.
that. Not me.
Proceed.
All right. Mr. Sharp, can you state your full legal name and spell your last name for the record?
Peter A. Sharp, SHARP.
And Mr. Sharp, what is your role with the city?
I am the mayor for the city of Soap Lake.
And how long have you been the mayor?
Since elected or since appointed, maybe almost a year, I believe.
Okay. And what is that a paid position or is it a voluntary position?
It is a paid position.
Um, and do you have a secondary job?
I do.
And what's your secondary job?
It is construction.
Okay. And have you ever done any work for or at Ryan Cox's house?
I have.
Okay. And are you licensed as a contractor in Washington State?
I am.
I
Okay. When
object to the relevance of this line of questioning.
it's just background. So, Mr. Sharp, can you tell me what steps the city took in a public session or a executive session without going into any confidential protected information under Washington law to decide whether to ask for the recusal of the chair of the Civil Service Commission?
I can't discuss any matters that happened inside of executive session.
I wasn't asking for you to discuss matters within an executive session. I was asking you to identify for this commission when the city council voted publicly to seek the recusal of the chair of the Civil Service Commission.
Object, it's irrelevant, related to strategy, related to litigation.
Who makes a ruling on Ms. Norton?
Well, you make the ruling, but I'll tell you that the rules of evidence are fairly lax in a proceeding like this. And I would, unless things go really far astray, I would suggest you allow the testimony because we will be able to go through it after the hearing, and we can parse through what is relevant and what is irrelevant information that's been provided.
Well, I'm unsure at this point where it's going, but that'd be the point to continue without.
Yeah, I think you should just overrule the objection and allow the witness to continue.
Go ahead, Mr. Cannell.
So let me rephrase my question. Mr. Sharp, there wasn't ever a council vote to ask for the recusal of Mr. Gravel. You made the decision unilaterally and directed the city attorney to do so, correct?
I don't believe it was unilaterally. Restate the question.
Okay. There was never a public vote by the city council to move to recuse Commissioner Gravel from the Civil Service Commission. You unilaterally directed the city attorney to make the motion to recuse him, didn't you?
Object to the form of the question. He's asking whether there was a vote to remove Mr. Gravel. No one is seeking his removal. We are seeking his recusal as a.
Ms. Norton, the rules of evidence don't apply. It's clear in the RCW. So I would ask that the witness be instructed to answer my question and that I not be interrupted.
Okay, Mr.
If I could
Sedaris.
comment, I think Mr. Tennell, Ms. Norton has the right to state her objections. And I think this objection is probably one that has some merit, but I assume that what you mean by.
I'm going to rephrase it.
Thank you, that would be helpful.
Mr. Sharp, was there a vote by the city council in open session to direct the city attorney to make a motion to have Mr. Gravel recused for purposes of this hearing?
City council didn't make a decision to recuse anyone.
That wasn't my question, sir. My question is, did the city council hold a public vote to direct the city attorney to make the motion to recuse Mr. Gravel? A yes or no?
No.
Okay. You made that decision yourself and directed the city attorney to make the motion, didn't you?
There was an agreement, not agreement, but there was a motion that I put to her that it is a conflict.
Okay, what do you mean there was a notion you put to her? Where was that motion made?
Not a motion, that was me just talking. Like, I believe it is a conflict.
Okay.
Again, object that this is infringing on discussions strategic to litigation discussed in executive session with the council.
Well, the city does not have the right to unilaterally move a decision like this without holding a public hearing on it and voting in a public forum. And this witness, with all due respect, was not hired by a police officer by my client because he failed a psych test.
Excuse me, object. The facts that are not in the record. Object. There's no basis for this foundation. Absolutely not. This is
I am allowed to
improper.
Please don't interrupt me. I am.
Both of you please cease for a moment.
I think Ms. Norton's objections are meritorious. I think that any discussions that might lead to revelation of attorney-client discussions is not relevant, nor is your arguments or statements relating to Mr. Sharp's background. That's not in the record, nor do I think was there anything in the materials that you provided where this argument was presented, unless you can tell us otherwise.
Well, I don't have to reveal all of my strategy in asking a witness.
I'm attempting to listen to the folks up on the screen, and I'm hearing comments from the audience, I believe, but I'm not looking over here to see. Am I hearing comments out here?
Yes.
Okay, so whoever's making those comments, you must stop or leave. You have a choice. So anyone making such a comment, no more. And Chief, if you would keep your eye open for that, because I'm attempting to watch this. And if someone out here continues With that, you'll please ask them to leave. Thank you.
And Mr.
So-
Tenor, yes, you have the right to make argument, but this is not, you are in direct examination at this point.
All right,
If you
I'll,
want to
I'll,
make your argument later on, you can do that, but this is
I'll-
not the appropriate time for it.
I'll ask a question. And I want the record to reflect that the current chair of this commission just identified Mr. Gates as the chief instead of an interim chief, which is one of the pieces of evidence that I'm seeking to explore as to the bias of this proceeding.
Object to the
Miss Norton,
relevance
please
of
stop
this.
interrupting me,
Oh,
okay?
well,
And
I'm
I
allowed
will
to for
just,
objection. You're
I'm
making
I'm in the
argument that is not appropriate for the direct examination of the witness
I'm in the
on
middle I'm in the
stand.
middle of asking questions. I have a right to make a record.
Mr. Canal,
Okay, I want to say one thing very clearly. Okay?
the interim officer who is serving as chief. Thank you.
Okay. I want to make something very clear here. Okay? I have the right to have a full record made of the questions and answers without being interrupted. I can assure you that if there is a recusal of one of the members of this commission, we will immediately proceed to the Superior Court for a declaration that it is unlawful, because what the city is attempting to do, in my opinion, clearly violates the RCW. It is very important, and I would like the commission and Mr. Sedaris to understand that I need my questions clearly collected by the record, because when either side appeals this ruling, the commission has to pay for and have a complete transcript made of the proceeding so the court can review that under the statute. If I am being interrupted by either the audience, the chair, or Miss Norton, and this is an audio recording, the Superior Court and the transcriptionist is not going to be accurately able to transcribe these proceedings for a court to review those. So I'm going to ask again very calmly to please not interrupt me when I'm trying to make a record for my client, because it is going to hamper the court's ability to look at what is going on here.
And Mr. Tennell, your points are well taken. I would ask that you remember this is direct examination and not argument, and that you'll have your opportunity to present your arguments, but that should not be occurring during your direct examination.
So, Mr. Sharp, let me ask you some questions to get at what I was trying to get earlier. There was no public vote, was there?
No.
You requested through the city attorney, and I'm not asking for the revealing of attorney-client communications, but you directed the city attorney to try to remove or file a motion to remove Mr. Gravel, correct?
There was a
Object,
motion.
it's not removal, it's recusal.
Recusal. Go ahead.
There was I did put a letter out, whatever, to have him recused, correct?
Okay. You made that decision on your own, correct?
Correct.
Okay. Now, you're the individual that decided to terminate Chief Cox, correct?
With guidance, correct.
From Miss Norton, your attorney.
And our insurance company.
So your insurance company advised you to terminate Chief Cox?
No, we have risk management agency that has attorneys for the city as well.
And which insurance company was that, sir?
Association of Washington City.
Okay. Now, prior to becoming mayor, you applied to be a police officer in Soap Lake, did you not?
Object, irrelevant.
The rules of evidence don't apply.
Yeah, and I would say let him answer, but this is something that when this hearing is reviewed, the relevance of this testimony will be examined.
Mr. Sharp,
So-
you prior to becoming mayor, you applied to be a police officer, correct?
Right.
I'm sorry?
Correct.
Why weren't you hired?
I'm unaware. That's irrelevant for me, though. I was not, yeah.
Who made the decision not to hire you?
Object to relevance. This whole line of questioning, if it relates to facts, ultimately at issue as to bias in the hearing itself, we can explore it then. But this is solely related to the recusal of a commissioner for very objective violations of appearance of fairness. It has nothing to do with the underlying disciplinary action of the chief.
And Mr. Tennell, I think you're going to be allowed to continue on with this witness, but I can tell you I agree with Ms. Norton that the issue before the commission right now is not anything to do with Mr. Sharp. It has to do with the appearance of fairness involving Commissioner Gravel. So just a warning, word of caution for you.
Thank you. Who decided not to hire you, Mr. Sharp?
I do not know because no documentation or emails or phone calls or anything in written form was ever given to me. It just kind of went to a standstill.
Okay. After becoming mayor, did you ever review any of your files related to your application and fair to be hired?
No,
Have you had any conversations with Mr. Gates since you appointed him interim police chief about that?
acting chief.
Object relevance.
Go ahead. Have you had any conversations with him?
No, I have not had any conversations with acting Chief Gates regarding to that.
All right. So, who all did you discuss? So you submitted two declarations for purposes of this motion to recuse, correct?
I believe there was two.
Who all did you discuss those with outside of your attorney? I'm not asking for attorney-client communications. I'm asking you to identify all third parties that you discussed the recusal with in order to draft those declarations.
That'd be with the city attorney.
I understand that I understand you had assistance from the city attorney. I'm asking you, who else did you talk with the recusal about besides the city attorney?
No, the recusal was only talking to the city attorney myself.
You did not have a communication with any third parties in order to gather the information that you put into two sworn declarations.
Not that I remember, no.
I guess I object to the characterization because are you asking about, or maybe to the form of the question, because
Ma'am, he answered my question. I'm moving on.
are
Thank you.
well, no, I think it warrants further review. Are you asking
You
for
can ask him that
preparation
on
of,
cross-examination. That's what cross-examination's for. So he answered my question. Thank you. I'm moving on. All right, Mr. Sharp. When you made the decision to hire an outside entity to investigate Chief Cox before his termination, correct?
object to relevance?
Go ahead and answer.
There was outside agency we were recommended through our Washington City's insurance as well as the attorney that we should do it outside of the city, outside of Grant County.
And who did
To
you
be
hire?
That would have been Wenatchee Police Department.
Again, I'm going to object to this line of questioning. He's asking him to enter facts that haven't been put on the record yet, that are ultimately relevant to decisions far down the road that have nothing to do with the immediate recusal proceeding. Now, I'm going to object to this witness being on the stand if these questions aren't relevant to the recusal of a commissioner that is in this matter, not the facts regarding the investigation, not the facts of the discipline, just the recusal. We have a whole pre-hearing process that we still need to get through. We haven't even touched on how evidence in the actual hearing will be addressed. This is a limited hearing for the sole purpose of determining whether there's been a violation of the appearance of fairness doctrine that would require a commissioner to be recused.
So, Mr. Tennell, I agree with Ms. Norton. I know that there's a great deal of leeway given in these proceedings, and the rules of evidence are guidelines and not strictly adhered to, but it seems like this line of questioning would be more appropriate during the hearing on the ultimate issue and not on this hearing regarding the appearance of fairness involving Commissioner Gravel.
I want to chime in on that. I agree with what Ms. Norton is saying, but in the extensive materials that have been received by the commissioners concerning the motion and all, it does move forward into that business of the later, the thing that follows the recusal, which comes next. And some of that was submitted by Mr. Sharp and Ms. Norton. So, but I do think it'd be a good idea to not be venturing out into what comes next. Keep it to why are we seeking a recusal or denying a recusal at this time, and not getting into the business of the firing of Mr. Cox, which is a second matter down the road.
Mr. Sharp, do you have a Facebook account for your role as mayor? Or do you only use one Facebook account?
I'm not understanding the relevance.
Okay. Do you have more than one Facebook account, or do you only have one?
I have one.
Okay. And is it your name on it?
Correct.
Okay. You don't have a second one for being mayor?
No.
Does the Soap Lake City Council record their city council meetings?
City council does not record.
Why is that?
Infrastructure.
Do you believe it's required by state law to record city council meetings?
I would refer to
Jack
the city attorney.
seeks a legal conclusion.
I'm just asking for your opinion, sir.
It's not an opinion.
To your knowledge, is it required to record city council meetings, Mr. Sharp?
I would advise go through legal counsel for that for the city. That's on behalf of the city, not myself.
Have you ever sought a legal opinion about whether recording city council meetings is required?
Not to my knowledge.
Have you ever looked up or personally researched whether it's required to record city council meetings?
To relevance.
Go ahead. Please don't interrupt me, Ms. Norton. Go ahead
I
and
can
answer.
I can interrupt for objections.
No, you need to wait
She can interrupt before he begins his answer. That's the whole purpose of the objection.
Thank you. And that's not happening. She's interfering with my making a record, which is why I'm asking her to wait until I'm done with my question so the court can review this. So my question was, for the record, has Mr. Sharp ever personally researched whether it's required under Washington law to record city council meetings?
And Mr. Tennell, could you just maybe explain why that's relevant to the proceeding we have here on the appearance of fairness doctrine?
It goes to the city's bias, and it also goes to the appropriateness of the city attorney continuing to serve in representation of the city when she's previously given my client legal advice. And I need to explore the foundation of that through this witness.
Wouldn't that be a separate proceeding?
Correct.
But I don't think it would be.
Well,
because it goes to it. I don't want to argue with you, Mr. Sedaris, but it goes to the quality of what has been presented to the two remaining commissioners and the fairness to my client of this proceeding. And I think it's also important to a reviewing court to have that information.
So shouldn't the commission be deciding the appearance of fairness based on the conduct and actions of Mr. Gravel?
No.
And even if the basis for the request for recusal is challenged or questionable, that would lead to potentially some type of separate proceeding, but not. I think that if the request for recusal is made, then it has to relate to the conduct and actions of the person who is subject to the request. And it doesn't really, I guess I'm having a really difficult time seeing the relevance of these questions to that issue. But I understand that you can ask the questions. It will be part of the record.
Sure.
But that doesn't mean that the commission will necessarily consider it.
Well, I guess I'll wait for the commissioner to make a
Yeah.
ruling on the answer and whether a court agrees with
Yep.
me or you or them or Miss Norton. So,
Yeah.
but it seems very clear to me that this decision, whichever way it goes, is going to be reviewed immediately by a Superior Court judge. I think it's in the best interest of all the parties who are spending money on this to have a full and complete record before the court reviews that.
And yes, go ahead and make your record.
Okay. So, uh, Mr. Sharp, can you go ahead and answer the question?
Can you please restate the question?
So I asked you, I want to make sure I'm tracking this. You did not personally research whether it's required under Washington law to record, or whether it's required under Washington law to record city council meetings, correct?
Are you referring to the Open and Closed and Public Meeting Act or just in general?
Whatever source of law may provide that answer, sir. I'm asking if you ever researched that issue.
I have looked through research through the Opium Act. That's it. And
Okay.
through whoever trading through the AWC or MSRC.
All right. But you earlier testified you'd never sought a legal opinion on whether that's required.
Oh, no, we can see through MSRC. That's a service that they provide, but not a legal counsel that I've purchased or paid for.
What do you mean by MSRC?
MSRC or AWC, you can ask their employees, which they have free attorneys as well, but it's not anything that's paid on your person. They're just relevant questions that you can ask them. What you're allowed to do in open public, what are you allowed to close public, what are you doing, roles and responsibility as counsel or as an elected official.
Okay. So earlier I asked you whether you had had conversations with anybody personally in order to prepare for your declaration. Do you remember that question?
For the two documents that were sent
Yes.
in for the recusal?
Yep.
Okay.
Okay, so this is a document that was filed by Miss Norton. And you put in here in paragraph 3, you put, he has had personal transactions with Chief Cox, including selling him a home for his family. Okay. How, other than through the Facebook page, which I'll get to in a minute, do you have another source of knowledge as to Chief Cox and Mr. Gravel's personal business dealings?
I don't understand the relevance.
Okay, your job, with all due respect, is not to understand or opine upon the relevance of my questions. If I
I'll
ask
give
a
you an
question,
honest
you need to answer it unless it's objected to and sustained by the chair. Do you want me to repeat my question?
Yeah.
Okay. Other than the Facebook post, which is Exhibit B, do you have any other basis of knowledge regarding Chief Cox and Mr. Gravel's business dealings? Or do you base paragraph 3 entirely on a Facebook post by Mr. Gravel?
Just through them talking back and forth and the conversations that I've had with Ryan Cox, they were friends for a long time.
Okay. How did you obtain the Facebook post that's Exhibit B to your declaration?
That's all. That's open to anyone on Facebook.
Are you Facebook friends with Mr. Gravel?
No,
Are you Facebook friends with Chief Cox?
no.
So who gave you Exhibit B?
Anyone can go look at people's profiles and or go through rant and raves or any other media group that you guys are anyone's a part of. You can view all that information.
Mr. Sharp, who provided you the copy of Exhibit B that is attached to your declaration?
Facebook. I don't know. Sure.
Where did you obtain it from?
Can you show me Exhibit B?
Did you read this declaration before you signed it?
Yes, sir.
Okay. Exhibit B has an attachment, or I'm sorry, your declaration has an attachment, Exhibit B, which is a true and correct copy of a Facebook post dated May 6, 2019, approximately 6 years ago. Where did you obtain the Exhibit B, which is the Facebook post?
I'd have to, I don't remember at this time, no. I didn't think I was gonna be talking today.
Did you provide Exhibit B to Miss Norton?
I'd have to see Exhibit B to be
Okay.
aware of it again.
Let's go ahead and go to Exhibit B. Okay, do you see this?
Correct.
Okay, where did you obtain that?
Oh, they're all on Raymond Gravel's Facebook.
But you're not Facebook friends with her.
Doesn't matter, you can still view people's profiles.
Okay, so this is interesting because it says comment as Julie Norton. Did Miss Norton find this from Facebook and attach it to your declaration for you?
That might have been possible because I requested that I notified that it is there. So she did see it. I do have screenshots to show that too as well.
Okay. Um,
Sometimes it's easier than sending a link to tell a person, hey, look at this.
all right. Next, paragraph 5. On November 8, 2024, I was made aware that Chief Cox may have accepted or agreed to accept a gift of meat. Who advised you of that?
Object, these are facts that are relevant to, this was just submitted as background. These are facts relevant to the ultimate issues at play. It was setting a timeline in terms of information that's already in the discipline letter.
With all due respect, these are the facts upon which this motion to recuse a civil service commissioner, the chair of the civil service proceeding, who does not want to be recused and who has submitted information on his own behalf. And I think before the commission wants to rule on that, I would imagine they would want to know the veracity of the declarations upon which they are proceeding, which is why I am trying to get to the basis of the hearsay in paragraph 5, which, by the way, the city provided. So I think if a decision is going to be made on Mr. Sharp's declaration, it would be fair game for cross-examination, and I should be entitled to answer that, have that question answered.
And I agree with Mr. Tennell on that. This is material that was provided by the city, and he should have the right to question the witness about these statements, these declarations.
All right. So going back to paragraph 5, Mr. Sharp, who made you aware that Chief Cox may have accepted or agreed to accept a gift of meat?
Who was the original person that found out that he received the meat?
No. My question for you, sir, is you wrote and swore under oath on November 8, 2024, I was made aware that Chief Cox may have accepted or agreed to accept a gift of meat. Who made you aware of that?
That would have been advised through our city's attorney
Wait a minute.
and our Washington City.
So Miss Norton is the first person that made you aware of this? You didn't know any other way?
I know because I was there.
What do you mean you were aware?
So it was says, I'm aware that Chief Cox may have accepted or agreed to accept a gift of meat related to his service as law enforcement is because I was there.
What do you mean you
When
were
the meat
there?
was dropped
Where
off?
were you?
At the police department.
Okay. So why does your declaration not state that I was present when meat was dropped off at the police department?
Because if you think about it, if I said I was there at the police department or I was aware I wasn't aware that at that time it was going to be accepted as a gift or gratuity or whatever, but I didn't know what the laws were until I sought legal advice from the city.
So you watched the individual drop the meat off at the police station, right?
Correct.
Did you have conversations with anybody about it?
With the gentleman who dropped the meat off, or the city attorney, or our Washington City's insurance company?
Well, was the city's attorney present when the meat was dropped off?
No,
Was the Washington City's insurance authority present when the meat was dropped off?
no.
So who was present when you watched the meat get dropped off?
Myself and Acting Chief Gates.
Yeah. So acting chief Gates was already acting chief on November 8 when you were present and the meat was dropped off?
No, don't twist it. So Acting Chief Gates, I'm referring him to as present. At that time, it's Officer Gates.
Okay, so are you telling me that Chief Cox wasn't even present when the meat was dropped off?
Correct.
So who was the meat handed to?
Officer Gates at the time, now Acting
Object to
Chief.
relevance. These are all issues that
Okay.
that go to the ultimate issues of fact for this hearing.
So did you have a conversation with the
Just a
person that dropped the
moment.
meat off?
Norton's comment there, I want to allow what she said.
So, Mr. Sedaris, you've already advised the commission that I should be able to go towards the facts in this affidavit, which now we're hearing a completely different version of events than what was written here. And
Object to that
I'm inter
characterization.
I'm
He's fishing for information to elaborate on things that aren't even in the declaration. The declaration simply states that he was aware of a claim, and that's the basis of the admin leave. It has
Yeah,
nothing
so
to do with who was there or what conversations were had.
well,
yeah,
this
Mr.
is
Tennell, I think that you can ask questions about the declaration itself,
yeah.
but when you start getting into the merits of the investigation or the facts that led to the investigation, those are all things that
Well, but
are
yeah,
properly before the commission on the ultimate issue.
I am asking about the declaration because
Okay.
the testimony that's being elicited about paragraph 5 is different than what was written. This is a sworn statement under oath. And now we're hearing testimony that is inconsistent with this document, upon which this commission is asking to fundamentally
Object to the
alter.
character.
Ms. Norton, Mr. Sedaris, I
Yeah.
want an instruction to Ms. Norton to stop interrupting me, or I'm going to object and ask this to be reset until
Objection.
everybody can be in person and I can have a court reporter to take down everybody's testimony. Okay? This
Ms.
is
Norton,
not
if you could
fair
let
to my client.
Ms. Norton, if you could let Mr.
Oh,
Tennell complete his questions, unless he's getting into areas of privilege, he can ask his question, understanding that this hearing is about appearance of fairness involving Commissioner Gravel and not the ultimate issues. And what gets reviewed and considered by the commission is going to relate to the appearance of fairness doctrine involving Commissioner Gravel.
Thank you, and I understand that. I just am objecting to the characterizations given to what has occurred with review of this language and the impact of bias it will have on these commissioners hearing inaccurate ways in which this analysis is discussed. I don't even know how to explain it as an objection, but it's
Well, I think you let him state his characterization, and then you place an objection in the record to the characterization, and that will be sufficient for us to review it.
All right. So going back to my question, did you have a conversation with the gentleman that dropped the meat off on November 8th?
object. I believe you've already had a sustained objection on this, that this goes to facts
I'm not
relevant
asking
to
about
the
I'm not asking about the facts. I'm asking if he had a conversation, and if he did, why it's not in this paragraph.
And Mr. Tennell, you've asked that you not be interrupted. I asked you to give the same courtesy to Ms. Norton and not interrupt her while she's making an objection and putting it on the record.
Thank you.
I thought she had finished. Okay, I'll try again. I'm not asking for the content of the communications. I'm asking for a yes or no. Mr. Sharp, did you have a conversation with the gentleman that dropped the meat off on November 8th in the presence of Mr. Gates?
I did not personally talk to the meat gentleman.
Okay. Did the meat gentleman talk to Mr. Gates?
The meat gentleman did talk.
Why did you not put into your declaration what that discussion was?
I didn't see the relevance. It was just meat. I didn't see this is the scope of it, not in great grand detail.
Okay.
Mr. Sidarius? Mr. Sidarius?
Yes, Commissioner.
Earlier on, when this testimony began, I said I didn't understand some things, but maybe I would as they went down the road, it would become more clear to me. But I'm not understanding, just as a layman here, how the questions relate to the question before us, which is the recusal of a commissioner. I'm just not sure how Mr. Thinnell's questions are tying to the question before us.
And I don't disagree with that. I made the comment that the rules of evidence in these types of proceedings are not directly applicable. They're guidelines, and there's a great deal of leeway given to counsel in terms of what they can present and how it is presented. Keeping in mind that when this gets reviewed, we will look at what is relevant and what is not relevant. I think what Mr. Tennell is doing at this point is challenging the veracity or the credibility of the witness when he put this particular declaration together. And to that end, some of the questions might be relevant, but when he's getting into the details of the investigation or what took place or what didn't, I think that's where I'm also struggling to figure out why it's relevant to this proceeding. But again, there will be a record. We'll have a chance to review it. Those things that are not relevant will not be considered.
All appearances are that this is a fishing expedition on his part, nothing more. Has nothing to do with what we're here for today.
I didn't put it in exactly those terms, but we have the same feeling.
Is that the other commissioner that just spoke?
That was Mr. Spencer.
It's not Mickey Mouse.
Oh, so I would just state that I think both commissioners owe my client a duty of fairness, and comments like that before we're not even ready speak to the concerns that I have that will surely be addressed by a judge in Grant County based on what appears to me to be a lack of objectivity by the remaining commissioner that just made that comment and said it wasn't Mickey Mouse. And so I would move to recuse the commissioner that made that gratuitous and unprofessional comment from further proceedings.
Mr. Tennell, if you want to bring a request for recusal after this hearing is concluded and decisions are made, then
I think the RCW requires me to do it right now, and I just did it.
It will be considered in due course.
Okay. Mr. Sharp, you then write in paragraph 6, despite the directive, I received confirmation that Commissioner Gravel spoke with Chief Cox and others regarding the basis for the chief's leave and status of the investigation. Who did you, because earlier you testified you didn't talk to anybody else before you drafted this declaration. In paragraph 6, where did you receive the information, or as you wrote, the confirmation that Commissioner Gravel spoke with Chief Cox and others regarding the basis for the chief's leave and status of the investigation?
And again, before he answers, I'm going to object to the way he initially phrased his question about who helped him with this declaration. There's a difference between who helped you prepare the declaration and who did you speak with that informed the facts within the declaration. Your question was, who helped you with the declaration? Did you speak to anyone else preparing the declaration? Not, did you have communications with anybody that is relayed in this declaration? And there's a difference in the way that you are trying to move it and characterize it. And that is probably creating unnecessary confusion in this proceeding. Yes, he had prior conversations to putting this declaration together. When it came down to writing it down, you, as well as I know, we put the declaration together based on the facts as we know them that occurred over time. So there's a difference, and you didn't phrase it that way.
Is the city's attorney volunteering to be my next witness by trying to give testimony?
Well, I don't hear even, yeah, there's not there's an objection, but I didn't hear other
It's
than
just
the form of the question,
yeah.
which I assume.
Yeah, the characterization, form of the question, it kind of all goes to that because he's asking about different things than what the original question was.
And I think Ms. Norton is correct on that, Mr. Tennell.
Well, I asked it 3 times just to make sure that he understood it. I'll trust my recollection better than Miss Norton's. Mr. Sharp, earlier you testified that you did not talk to any third parties. It's the way that I phrase the question. I asked you if you talked to any third parties to prepare this declaration, and you said you didn't. So my question is, specifically with paragraph 6, how did you receive confirmation that Commissioner Gravel spoke with Chief Cox?
I believe that's out of context. They're not the same thing. If I was to have any communication to find out that Chief Cox had communications with everyone else, that is a separate, completely separate timeline, a different, different date, not the same point for drafting this at all.
Okay. Who did you receive confirmation from that Commissioner Gravel spoke with Chief Cox?
I've talked with council members. I've talked with people coming into the city hall. Everyone talks. Everyone comes in the city hall. I mean,
Mr. Sharp,
people just tell you, hey, they talk with people.
please give me the identities of anybody that you received confirmation from that Commissioner Gravel spoke with Chief Cox.
Susan Carson.
Okay, who else?
They're listed in the right here, number 6.
I'm asking you for everybody that told you Commissioner Gravel spoke with Chief Cox. Who else besides Susan Carson?
We have citizens here that talk to council member Susan Carson would be Bird Beckwith.
Okay.
They're listed there. Joanne Rushton did talk. They are friends. Bird Beckwith, I believe, tried to call Susan thinking it was Joanne, but it was not.
Okay, so to be clear, are you testifying that Susan Carson specifically came to you and told you that Commissioner Gravel told her that he spoke with Chief Cox about the investigation?
No, I did not say that.
Okay, so who told you specifically that Gravel talked to Cox?
I believe you're trying to twist things around here a little bit. I heard it from either council members, Susan, that she's received phone calls, that obviously there's communication. Obviously, I can't discuss closed public meetings. So I would refer to the city attorney for discussions for that particular reason and how things are being notified or found out. But
Okay,
the people are listed on there too as well.
So let me ask you this question. Outside of an executive session at a city council meeting, did you ever hear from any other source outside of a closed executive session of a city council meeting that Gravel and Cox discussed the investigation?
Just through Susan, hearing other phone calls. I've talked to people on the phone.
Who did you talk to on the phone?
I have talked to Bert Beckwith on the phone. I've talked to Susan on the phone. I've talked to other city people who live in residents in the city.
Okay, that's not my question. Did Burr Beckwith personally tell you that he knew Gravel and Cox had talked about the investigation?
Indirectly, yes.
What do you mean indirectly?
The things that he knew, the only person that would know that would have been Ryan.
Okay, that wasn't my question, sir. Did Burr Beckwith tell you that he had firsthand knowledge that Gravel and Cox spoke?
I can't state that in a formal question, in a formal answer. You know,
Well, it's either a yes or no. I
Thornton,
mean,
I don't recall.
did
so
counsel, it is grossly improper for you to suggest to your client in an open session what he needs to answer under oath.
Well, you're telling him he,
You've been practicing long enough to know better than that. So let me ask
Mr.
my question
Sedarius?
again.
Mr. Sedarius?
Yes, it is improper,
Struggling,
Ms. Martin, to
struggling with
suggest.
what we're attempting to establish here with the current questions from Mr. Thinnell. And would it be possible to have him speak to that and then move on to the next point, whatever that is? Or
Certainly.
do I just, we're patient?
No, I think you can ask Mr. Tennell to
I'm happy to address
explain the
the.
relevance of his line of questioning.
and before he
What-
does that, I'd like to say, I do apologize. I did not mean to instruct the witness, but I do object to him also instructing that there's only two ways to answer the question. The witness is being caught off guard by the fact they have to testify today. We did not receive any advance notice that this was an issue. This declaration was filed several days ago, and there was no indication in the reply that any of these facts were going to be raised at this hearing. So a little bit of leeway and patience with the witness would be appreciated. But I do admit I did not mean to help instruct the witness. In any case, I do feel it's appropriate to point out that both Chief Cox and Mr. Gravel admitted to these communications. So to the extent that we can summarize and move on, that might be helpful.
That's what I'd like to see.
Mr. Sedaris, would you like me to explain why I believe this is relevant?
I think you should, for the commissioner's sake. Yeah.
Sure. So it is Chief Cox's position. It is Chief Cox's position that the basis of the motion to recuse Commissioner Gravel is full of inaccurate statements. We're not sure if some of the information is even true. And it is full of hearsay. I also suspect that it is based on, and I think there's support for what just was elicited in the mayor's testimony, that this declaration was prepared at least partially upon what appears to be discussions in executive session that only the city council and the city's attorney are part of. And it is highly improper for the city to try to hide behind that executive session privilege and attorney-client privilege to weave together a declaration based on information in a closed session, try not to reveal unlawfully closed session information, but to remove a commissioner who has experience and attempted to do an investigation that is actually supported by state law based on the commissioner's duties. There's been high irregularities in this process. There is a very limited amount of case law on the removal of a civil service commissioner.
Object, we are not seeking removal.
And well, if we want to really be blunt, counsel and commission and Mr. Sedarius, there's zero language in the state statute about recusal of a civil service commissioner. If we really want to get down to it, and we really want, then the commissioners and the the remaining members should probably be mindful of what RCW 41-12-030 actually says, which I happen to have up, and I will display it for purposes of responding to the commissioner on why this is relevant. Okay. A civil service commissioner may only be removed for 4 things. There's no mention of recusal. That does not exist in the statute. The only way a commissioner may be removed is incompetency, incompatibility, dereliction of duty, or malfeasance in office or other good cause. The city's attorney has stipulated on the record that there was nothing done intentionally or in bad faith. That fact alone shows that the effort to have a commissioner removed from this proceeding based on this statute has to fail as a matter of law. There is no basis in state law to recuse a civil service commissioner. There is a basis in law to remove it for one of those reasons in the statute, and the Soap Lake rules themselves conflict with this statute. They are inconsistent with this statute, and the statute has to trump. And so if you're going to base a motion to recuse a civil service commissioner when there's only 3 of them, and it's based on the declaration of a person with clear personal animosity against the victim of the termination, and you don't let me go through the potential for the bias in the declaration, the inaccuracy in the declaration, the hearsay in the declaration, all you're doing is leaving this body subject to further judicial challenge. We've already had 2 instances where this witness testified inconsistent with his declaration, and I'm only on paragraph 6 of the first declaration. That's the relevance to my question.
So,
And if
Commissioner Slipper, may I comment on that?
Go ahead.
So, Mr. Tennell, you brought up a number of things, some of which I don't think are going to be resolved in any proceedings here, that are probably going to have to be resolved at a higher level, which is applicability of the appearance of fairness doctrine to civil service commissioners and good cause and those types of things. That's not an issue that's going to be dealt with here. I don't believe. So the other issue is the bias or the credibility of the information that is being presented in support of the recusal, and that I do think is relevant. But I think that you make your points. I think you need to move on, particularly on issues where there may not be a dispute based on other material that's in the record. So, I mean, I get that you want to go through the declaration and challenge Mayor Sharp's credibility on those things, and I think you should be allowed to do that. But I think you need to keep in mind that the ultimate goal of this hearing is to determine whether Commissioner Gravel did things that would violate the appearance of fairness doctrine, and the issue of whether it even applies is something that will be discussed, obviously.
Yeah.
But here today, we are only dealing with Commissioner Gravel and his
Fair enough.
actions.
I'll speed it up. I appreciate your comments. So I want to touch briefly on paragraph 7, where he said multiple individuals have visited me at City Hall to report that Commissioner Gravel has been openly discussing private conversations he and Chief Cox had. Who are the individuals you're referencing in paragraph 7?
I don't have their names in front of me, so I wouldn't be sure to give you the proper ones.
So you don't remember anybody in paragraph 7?
There has been many people that came into City Hall. I don't know everyone personally now, but yes, they have discussed and brought up things that were talked about that they shouldn't have.
Okay. My question for you, sir, is as you sit here today under oath, are you able to provide to the commission any names that you're referencing in paragraph 7?
Well, the Facebook post would be a good one. There, a lot of people are commenting on the Facebook on Soap Lake Rants and Raves when and discussing matters that they shouldn't be talking about. So I oppose that. I guess that everyone in the comment range that made any type of comment that brought up issues that should have been discussed, they would have been notified.
How do you know people on the Facebook rants and raves didn't obtain information from public disclosure request?
I would have to check the timeline there. I don't believe they were privy to it then.
Okay. Now, had you ever personally reviewed the RCW on what the Civil Service Commission is allowed to do or what they're charged with prior to encouraging the city to move to recuse Commissioner Gravel?
Can you refine the question, please?
Did you ever look at what the duties of a civil service commissioner were prior to moving or encouraging the city to remove or recuse Commissioner Gravel?
So you're asking me if I've ever looked at the civil service rules before prior to the recusal.
Uh-huh.
I have in the past looked at the Civil Service Commission.
Okay. Did you look at the RCW or did you just look at
It would have been looking at in general.
Okay, did you look at the RCW or did you look at the Soap Lake civil service rules?
I do believe they have two different ones, but I can't recall.
Okay. So in paragraph 14, and I think that's the last paragraph that I want to show you from your declaration, you write, Chief Cox appealed his termination to the commission. After filing the appeal, Commissioner Gravel has attempted to reach out to the city attorney's office regarding the appeal hearing process. And then you attach an email. Is it accurate to surmise that Miss Norton gave you a copy of that email?
Are you able to show me the email you're referring to? I go through a lot daily.
Sure. Okay, this is Exhibit I. Did Miss Norton provide you this email?
Can you scroll down?
Sure.
To my knowledge, I believe so.
Okay.
I do remember this portion that was actually said out loud before, yeah.
All right, so let me ask you a couple questions about this. How did you come into possession of the civil service appeal?
Object to relevance.
I think you should go ahead and answer. I don't think that that should be sustained.
Can you repeat the question again?
How did you receive the civil service appeal from Chief Cox when it was sent to the commission?
I don't remember in detail right now.
Did the secretary hand it to you?
I do not recall. Again, I didn't know I was gonna be talking today, so I've been going through the budget and stuff today, so those things right now were not in my mind for today. So I would have to go through my, my emails or whatever and look over look over the documents that I submitted again today, because I was focusing on budget today, not focusing on having any type of hearing that regards to me. So,
Mr. Sharp, this appeal was issued about 30 days ago. And it was submitted to the Civil Service Commission, and it was hand delivered to Jody Siebert on about February 19th. How did you obtain it when she was the only person it was hand delivered to at the city?
I'm going to object. I mean, you personally emailed the copy to me, which I forwarded to my client simultaneously. So are you talking about an original or the copy?
Ma'am, would you like to testify after this? Because I would love to put you under oath and ask you questions.
Well, I
But
just think that's a professional.
you're testifying again. And so my question, I would like to have it answered.
Mr. Sharp, you need to answer the question if you can recall. If you can't recall, just let Mr. Tennell know that.
I do not recall.
Okay.
And Ms. Norton, I would caution you that I think you are getting into the realm of providing testimony. I think that's not appropriate.
Okay, thank you.
I don't have any other questions.
Thank you, Mr. Snell. City Attorney Norton, rebuttal argument?
Just a follow-up question for the witness. In regards to the Exhibit B, the Facebook post that was discussed, do you recall forwarding the link to me?
Oh, yes,
Did I print that for you?
correct, yes.
That's that's really all I have.
So Commissioner Slipper, this was just direct and cross-examination of the witness. Mr. Tennell has not made argument yet in defense of his position. I think that's where we stand at this point. Although I think you've probably heard a fair amount of what the argument will be, but he's entitled to present his argument at this point, in which following Ms. Norton would have a chance to rebut.
Yeah, and I will be brief because I've had to do a bunch of it within the context of my cross-examination. The rule under which the city, through the mayor and his attorney, are trying to remove or recuse Commissioner Gravel is flatly inconsistent with 41-12-040. And I am not convinced that there is clear legal authority on this, on whether this appearance of fairness doctrine even requires the removal of the civil service commissioner in this case. There is a dearth of case law under Washington law. And here's the other thing. If there is 3 commissioners, it takes 2. The city has moved to recuse Commissioner Gravel. I have moved to recuse a commissioner who made a completely inappropriate and gratuitous remark in response to me trying to make a record. I don't frankly know how you can proceed at this point with only one unless you bring all 3 back and have this go to a hearing. I have grave concerns over the fairness to my client of this process based on the testimony of the mayor. And I don't believe that the commission can recuse Officer or Mr. Gravel based on RCW 41-12-040 and 030. And I think that clearly limits the ability to remove a civil service commissioner. It does not allow for the recusal of a civil service commissioner. There is nothing in the RCW that does that. And if you look at 040, much of what, or some of what the city is objecting to is statutory authority of a civil service commissioner. If you look at RCW 4112.040, subsection 4, it expressly vests with the commission to undertake investigation upon all matters touching the enforcement and effect of the provisions of this. Such investigations may be made by the commission or by any commissioner designated by the commission for that purpose. There is nothing that is laid out in Commissioner Gravel's statements or in the city's very biased presentation of the mayor's position that indicates that is outside the authority of a civil service commissioner. It is within his right to do what he was doing. If the civil service commissioner who was objecting to the very procedures, and that last exhibit I think is very telling, this has not been handled appropriately by the city from the initiation of the appeal. The appeal was supposed to go to the Civil Service Commission. And at the beginning of this, Miss Norton was representing both the city and the Civil Service Commission, is why she got the civil service appeal. She has now transitioned to only represent the city. This was not provided to the Civil Service Commission for 24 hours, according to the Exhibit I in the city's proceedings. That should be a concern to the commission. It should be a concern to the community. It should be a concern to the citizens about the irregularities that exist. And if there is a forced removal or recusal of a commissioner that broached concerns about the processes that were being followed, what is that going to say about the underlying fairness of the Civil Service Commission, upon which is Chief Cox's only remedy to have someone review his termination? What he did is allowed by statute. What the city is attempting to do is not allowed by statute. That should end the analysis. I also think that Commissioner Gravel, who submitted a pretty impressive brief on his own with no legal assistance, should be allowed to address the other two commissioners and provide anything else that he would like based on his pleading. That's all I have.
Thank you. So, John Spencer, Commissioner Spencer, do you have anything you'd like to add?
Oh, I believe
Ms. Norton should have the opportunity to,
Cor-
yeah, she gets last word.
I thought
Correct.
we had reached-
So
Go ahead.
I do want to point out, because I feel this implicates CR 11, not trying to be a witness or anything, but I have never represented that I represent the Civil Service Commission in this matter whatsoever. I put that in writing to Mr. Thinnell that I was not authorized to accept service on behalf of civil service because of the inherent conflict. So I have never at any point in time indicated that I represent civil service in this matter. And I want that to be clear because I think that's potentially sanctionable.
Well, we had to serve you because you wouldn't tell me that I had the permission to serve him directly. So we had him served directly and served you.
Excuse
You
me, I didn't
didn't- you
interrupt
did-
your hearing.
Well, but you just
I-
accused me of doing something that's possibly sanctionable, and I'm going to respond to it.
Mr.
Because
Thinnell,
I
you'll
can-
have your
I
opportunity
can
to
present.
respond.
Hold on.
Yeah.
She didn't say she wasn't representing the commission until after this appeal was started.
That is actually not accurate, and I have it in writing. And I directed him to personally serve the city because I was not sure who would be representing the Civil Service Commission. Thank you. Going back to the merits of his argument, we're talking two different languages here. We are here for the purposes of a recusal of Commissioner Gravel. It is undisputed that he is engaged in conduct that violates the Appearance of Fairness Act. The Appearance of Fairness Act is a well-settled legal principle that overwhelmingly applies to this to this proceeding. It applies to civil service in this context. We cited to numerous cases in this state that apply it. He's trying to confuse two things. We are not seeking removal. We are seeking recusal, and recusal for the appearance of fairness. There is no dispute through Mr. Gravel's and Mr. Cox's own briefs that they had conversations with Mr. Cox after the mayor placed him on leave. That is almost incurable in this context because even though it predates the hearing, it would require me to now it would require Mr. Gravel to be a witness in a proceeding in which he's presiding over. Fulwiler is directly on point that you cannot be a commissioner and a witness or an investigator or adjudicator outside what functions you may legally have in this same hearing. That's fatal. I don't think the innocent comment that was made by one of the commissioners about himself, not about the proceeding or about another person, rises to any kind of a level of appearance of fairness. So I would object to any challenge to another commissioner being recused, again, not removed, recused from this proceeding because of any type of bias or prejudgment. I don't think that even hits any of the elements. So, if there's, if by chance there's still the doctrine of necessity that he could serve and or we could appoint a pro tem commissioner for the third if we needed three. But the bottom line is we are here for recusal under the Appearance of Fairness Act, which applies to the civil service in this context. The facts regarding Mr. Gravel's conduct, not the city's, is undisputed. It's in black and white. It's available for the public to see. The public has expressed their own concern that he has prejudged some of these issues in those comments or posts. That's what appearance of fairness is about. It applies in this case. He is clearly has to be recused to preserve the integrity of this hearing under this doctrine. And again, the city's bias as a party is irrelevant, completely irrelevant. This is about what Commissioner Gravel has done that could influence these proceedings. That is it. They will have all day to talk about whether the mayor did or didn't have cause to take the disciplinary action that is ultimately at issue. But this proceeding itself is about whether a commissioner needs to be recused, which just means excused, not removed, from a proceeding. There's very, very clear case law on point. We've cited to a ton of it. There are multiple examples in the record. He even admits to some of them. Recusal is appropriate in this particular case to protect the integrity of the proceeding. Thank you.
So this was the rebuttal opportunity. Are we done with rebuttal, Mr. Siderius? Have we?
I think, yes, I think we're done. I think we're done with this hearing. And the next steps would be probably for the two commissioners and I to have in executive session, have a conversation about, well, probably where we're going from here. We have a motion for recusal of another commissioner, and then we have to make some decisions on how to go about the deliberations.
Okay.
So for purposes of today's hearing, I think that we are done.
John?
I think we just need to adjourn and go to the executive session. I think we beat this to death to where we're all tired of listening. It could have been solved, I think, a lot easier if we just talked about appearance of fairness.
So Commissioner Spencer and myself will take this matter under advisement, and we will provide a written order at some point. Turn that over to Ms. Siebert. However, if anyone thinks that we're going to go into executive session and 10 minutes from now return with our decision, that will not be happening, at least in my opinion. this is what I've accumulated in the last 2 days concerning this, and I have looked at it, and now today we have these arguments, and I think these arguments today are going to have to be put in writing into a package that Mr. Spencer and I can refer back to clarify questions we may have. So yes, we will talk about this in, I suppose it will be an executive session type of setting, and we'll talk with Mr. Sidarius following this about setting that up. But there will be nothing quickly, I can assure you of that, because I personally require that I have the opportunity to take a very detailed, serious look at every page that's been submitted, and as a commissioner, I'll make my decision based on the totality of that, and I think Mr. Spencer will do the same. So certainly we will be doing nothing until Monday or Tuesday, because I have some personal matters that I'll be dealing with in the next few days, and so that's just the way it is. So, Rob, should we plan to have a phone meeting, Zoom, or however we do this, as early as tomorrow, just so we can clarify what our next steps are, and then we'll proceed?
We can do it tomorrow. If you're available, I would do it now, just so we can try to get something on track for what next steps are going to be. But I'm happy to do it tomorrow as well.
Yeah, when this meeting was scheduled on the 10th of March, I inquired about the length of it, because I did have other matters I had to deal with. And I was told it would be a 1 or 2 hour meeting. I don't know how long it's been now, but I've given as much time as I can for today. I'm sorry, that's simply the way it is. And so we will communicate, and we will come up with a plan.
I'm not available tomorrow.
Okay, well, when you have the similar problems I do.
Yep.
So we will meet with Mr. Sidarius though, and map out where we feel we need to go next. At some point, we will of course necessarily make a decision and provide a written order. And so there's nothing else for today. So I have a motion to close this meeting.
I make a motion to close it.
I'll second it, and I'll ask if there's any discussion, because that's the stuff I hear in the council meetings you're supposed to say. So having heard no objections and agreement by the commission, we will stand adjourned.
Thank you, council.
Thank you.